to hold these accused persons until today. The investigating team came under Article 49G. And that meant they explained to the accused persons why they are holding them and then ask for time. But now, one of the things that you are supposed to do, the moment you have done that, is to go back to that court and tell them what you have done. Or you file a record of the things that you have done, so that in case you're asking for more time, you tell the court what you want to do. Unfortunately, this is where they fail miserably. So then 49G then goes away. So we come in under 49H. The accused person has been brought to court within a reasonable time, subject to argument. But they are here. So the next thing they're supposed to do now is to give you compelling reasons. If we have to go by any definition of compelling reasons, that has to include the thesaurus and the Oxford Dictionary. It just means one thing. It must be forceful, that reason. It must be compelling. And most of all, it must be convincing. So this is what this affidavit is supposed to have. You know, these courts have seen so many authorities in relation to any allegations made by the prosecution. And let me just say, the reason why we have these fundamental rights is to prevent these excesses from the state. So they come and tell you the accused persons are going to interfere with the process. In Richard Alden versus Republic, and in the case of Swagerai versus Republic, what did the court say? For the prosecution to come and say that they are going to interfere with witnesses, they must show how they come to that conclusion. Not guessing, not assuming. How you come to that conclusion. And that must be by facts. So which witnesses are they saying are going to be interfered with? Where and when do they intend to do this? How did they come to this information? Do they fall under the category of what we call the protected witnesses or vulnerable witnesses? Then we have the witness protection program. So as we stand here, is that a compelling reason? Our answer is simple, no. Another reason is investigations. Why are we in court? Why did we bring the accused persons to court today if we have not completed investigation? And which investigations are these that you need to have the accused persons present with you? Because if you are going to talk about telephones, they do not work with service providers. If you are going to talk about statements from other witnesses, they are not the police. They do not do that work. If you are going to talk about data from the computers and all these things, they do not do that. Which other reason then is there? You know, it's very simple, because for them to have come with these reasons and they're not compelling, then what happens? Then the right becomes absolute. Initially it is not, but they fail, it becomes absolute. And so if it has become absolute, then Article 19 must come in, because that says very clearly, these rights are fundamental rights that belong to an individual and not the state. So they cannot come here with an affidavit that is so plain, such a blanket cover, and expect you to believe. Not today, not ever. In the affidavit, they are saying that the court only granted 1 day. But we all know that the accused persons have been in custody since the day they were arrested. Not 1 day. And if it was 1 day that they were supposed to have done this investigation and presented, why did they come to this court? Why did they waste that day and come here in the morning, when that day could have been utilized and go back to that court that they were supposed to go to? Doesn't that show you mischief? And if then you conclude that it is mischief, have they come to this court with clean hands? Then that will be the question. And if not with clean hands, then they cannot come and ask for equity. You cannot grant them that today, not ever again. Article 20 and 21 are very simple. They encompass the state, they encompass the prosecution, the police force, all of them. Everybody is supposed to recognize the fundamental rights of all these accused persons. And apart from doing that, you must start by wanting to grant, and that's what Article 21 says. You must want to start by looking at it favorably. And what is favorably? All fundamental rights are mostly made for the purpose of protecting the accused persons against the state, because the state has always been known not to be good. I'm not saying these ones who are not good, but I'm not saying they're good either. So when they tell you that this is now in the interest of justice, then what is the interest of justice? What about their bail terms? What about their fundamental rights? Can that not be justice? They must satisfy that act, and if they have failed, that is a problem. Because at the end of the day, we know who the first accused person is, and we know who the other accused persons are. But then, Article 28 is clear that you must maintain the dignity of a person. It is a fundamental right. Then what is dignity? Not to insist on keeping him in custody and making it like they want to just keep them there for torture purposes. The dignity is that he must be able to stand up and appear in court. He must be able to come out from his house. He must be able to stand in the crowd and be able to defend himself, maintain that dignity. Not to put him in custody so that he can come with people in green uniforms and blue uniforms. And I respect him. But then, does it save his face? He's a person who's known. Let him maintain that dignity. And that is why that article is there. It has always been a presumption, and in criminal case number 46 of 2017. Yes. If you look at paragraph 16 of that ruling, what does the court say? By the time you're bringing people to court, the presumption that you have done your investigations, you have completed and everything, is the time you bring them to court. So they cannot come and tell you that since they have not finished investigations, then that is a compelling reason. They can't tell us because that is their failure. Their failure cannot be an emergency on our part. Paragraph 17 of that authority is still the same thing. It talks about pending investigation, and the court says that is not in to deny the accused person constitutional right. That is a person of influence, that is a person who knows people, that is a person capable of interfering. It's not here nor there. That one is subject to proof. So today, do you have a compelling reason? Because I have searched high and low, and in this particular document, which again you will not even allow, is at best weak. The rest my colleagues have covered. It's a photocopy, but at least I'd want to confirm one thing. When somebody says in an affidavit, sworn before me, that means that person is present in front of the person commissioned. So when you bring a photocopy, where was it photocopied and made before it was brought to the commission? And then is it true? Is it a fact? Is it genuine? I don't want to say that they are lying, but then again, what else can I say? They are lying.